Jurisprudence and its relationship with other social sciences. Jurisprudence is like thinking and reasoning behind the law. Think of law as a rule that everyone in society must follow. Law is like the study of why we have the laws we have, how they work, how to make them fair. Simply put, when we talk about law, we are talking about big questions about law. Why do we need them? How do its people live in peace? What is the best way to determine which law is good or bad? It's like trying to understand the why and how of the laws that govern our lives. Law is not about memorizing laws like you memorize facts for an exam. It is more about reflection and criticism. It's about asking questions and trying to find useful answers. For example, if a law seems unfair, the law can help us think about whether it needs to be changed or whether there is a better way to solve the problem. Hence, the study of jurisprudence involves the study of different legal ideas and theories. It's like the big challenge where we try to figure out what makes policy fair and effective. It is a subject that challenges our thinking and helps us understand the principles that form the legal system we live in. Definitions of jurisprudence. Here are few definitions of jurisprudence by famous thinkers and from different law dictionaries. John Salmond. John Salmond's definition of jurisprudence is in two senses. In a wide sense, it means the science of civil law, laws of the land, and in a narrow sense, it is limited to only basic principles of law, the science of the first principles of civil law. John Austin. John Austin, a renowned legal theorist, defined jurisprudence as the science of positive law, or the systematic study of laws established by political superiors to govern the nature of citizens within a society. He emphasized that jurisprudence should focus on analyzing the command of the sovereign authority and its enforcement. H.L.A. Hart. H.L.A. Hart, a prominent figure in legal philosophy, defined jurisprudence as the study of the nature of law, examining not only the rules themselves but also the underlying social practices and concepts that give them meaning. He introduced the concept of secondary rules that enable the legal system to function effectively. Black's Law Dictionary. Jurisprudence in Black's Law Dictionary is defined as the philosophy of law, encompassing the study of legal principles, systems, and the theoretical foundations underlying the practice of law. It involves the analysis of legal concepts, their historical development, and their application within the legal system. Bouvier's Law Dictionary. According to Bouvier's Law Dictionary, jurisprudence refers to the science of law, or the systematic study of legal principles and doctrines. It includes the examination of legal theories, rules, and their interpretations, as well as the historical evolution of legal systems and their philosophical underpinnings. Ballantyne's Law Dictionary. In Ballantyne's Law Dictionary, jurisprudence is defined as the science or philosophy of law, involving the study of legal principles, concepts, and theories. It encompasses the exploration of legal history, the evolution of legal systems, and the analysis of judicial decisions and their implications. Merriam-Webster's Dictionary of Law. According to Merriam-Webster's Dictionary of Law, jurisprudence refers to the study or philosophy of law. It involves the examination of legal theories, principles, and the practical application of laws within the context of society and justice. Relationship of jurisprudence with other social sciences. Jurisprudence, the study of law's philosophy and principles has important connections with various other social sciences. Let's break down these relationships subject-wise in simpler terms. Philosophy. Politics and philosophy are deeply intertwined. Philosophy helps us explore the fundamental questions behind law and legislation. Justice examines concepts such as fairness and the nature of law. Legal science uses philosophical theories to understand the moral foundations of law, and examines the principles that guide the creation and administration of law. For example, the debate about whether punishment is a method of rehabilitation or punishment directly affects the law's approach to criminal justice. In this way, law and philosophy together bring to light the deep meaning and value behind the rules of culture. History. The relationship between law and history is like a treasure trove of understanding. Law is not static, they evolve as society changes. History provides a record of how law changes over time in response to cultural shifts, technological shifts, and human needs. Law examines this change to understand the reasons behind changes in the law and how they are currently made. By tracing the development of the law, the impact of historical events on the formation and reform of the law can be understood, and provide context warning for the application of existing law. Sociology. Sociology studies how people interact in groups. Law deals with sociology, which studies how law affects society. It highlights issues such as inequality and justice by examining legal structures and their effects on various groups. For example, examining family law from a sociological perspective shows how the legal definition of marriage and family influences change and social benefits. Political science. The connection between law and politics is the basis of administration. Political science is the study of how power is exercised and decisions are made. Law works collaboratively by analyzing the legal system in which the government operates. Explores the laws that define the government's laws and the process of creating and interpreting those laws. This relationship is particularly evident in legal situations where the interpretation of important rights is linked to politics, showing how both influence each other. Economics. Economics deals with resource allocation and trade. Jurisprudence is the study of the laws that govern business, including contracts, property rights, and competition. For example, contract law governs contracts, and its principles affect business transactions and commerce. By examining this relationship, law provides an understanding of how legal systems affect the economy, economic growth, and the distribution of wealth. Psychology. The interaction between law and psychology is in understanding human nature. Psychology studies patterns in the mind and nature. Legal science uses this information to understand how the brain affects the law. Mens rea examines issues such as ability to stand trial and the reliability of witnesses. Legal science improves the integrity and effectiveness of law by integrating knowledge from psychology to ensure that legal decisions incorporate human experience and thought. Anthropology. Collaboration between law and anthropology reveals the culture of law. Anthropology is the study of different cultures and their traditions. Law has benefited from the study of cultural practices in legal practice and vice versa. Legal pluralism examines the integration of various legal systems in society due to cultural diversity. This contribution contributes to our understanding of how law is understood and applied in different cultures, by revealing the interaction between local cultures and the legal process. Ethics. Ethics and law are interrelated when it comes to justice. Ethics is the in-depth examination of morals and values. Legal science integrates ethical theory to evaluate the justice of law. It measures how the law governs moral values such as human rights, justice, and personal freedom. For example, the debate on the ethics of surveillance involves legal considerations for balancing national security and personal privacy. This partnership ensures that the law is ethical and promotes a just society.